Africa Media. I am Amadu S. Bar. Welcome to the program Legal Matters, coming to you on Tuesdays and Thursdays live on our streaming platform. Today, we would be talking about the legal system of Sierra Leone and as well as its role during our elections. To talk about that, we have in the studio Emmanuel King, who happens to be our usual contributor. Mr. Emmanuel King, you are welcome to the program Legal Matters. Yet another edition, and today we want to look at the Sierra Leone legal system and its role during elections. So to start with, how do you describe the legal system of Sierra Leone?
Good morning, viewers, and thank you, Mr. Bar, for having me again today. The legal system of Sierra Leone can only be viewed in a very broad context, so we would have to contextualize our legal system so that the viewers can have a broad understanding of what our legal system is about and how it actually came about. So Sierra Leone is a constitutional republic. As a constitutional republic, every single arm of government is provided for by the Constitution. And by in a democratic setting as ours, the three arms of government, as was espoused by Baron de Montesquieu, is what we as Sierra Leoneans also follow. And these three arms of government are the executive, the legislature, and the judiciary. So section 120 subsection 1 makes provision for our judiciary. So as compared to the other arms of government, every single arm of government is independent and autonomous. The only bearing that we see that crisscrosses these arms of government has to do with appointments from the executive. So the Chief Justice, who happens to be the titular head of the judiciary of Sierra Leone, is an appointee from the executive arm of government. So that is where the executive arm of government has a link with the judiciary. But for all intents and purposes and provisions of the 1991 Constitution, the judiciary of Sierra Leone is supposed to be a separate, distinct, and independent body from the other arms of government. But we know that most of these things are said in principle, whereas in practice,
it doesn't really work.
It's a completely different thing that we see, as a matter of fact. As I've mentioned, the Chief Justice happens to be the head of the judiciary, and because our topic for discussion today has to do with the legal system of Sierra Leone, we will concentrate on the judiciary as a third arm of government. So the judiciary of Sierra Leone sort of oversees the legal system of Sierra Leone. So, like I was talking about linkages, the legislative arm of government makes the laws for the land. They legislate these laws, and it is the role of the judiciary to interpret these laws. To get perpetrators responsible for actions, to give relief to certain individuals. But by way of linkage, the legislative arm makes the laws, and the judiciary interprets the laws. The Chief Justice, who happens to be the titular head of the judiciary, cannot work alone. It's a very big judiciary. Of course, they cannot work alone. So he, who is the head, makes certain recommendations for appointments to certain courts in the land. And upon his recommendation, the president makes appointments of justices and judges to fill up the entire judicial system of the country. So as part of this discussion, we'll have to look at the hierarchy of the courts. We will look at all the constituent courts in our legal system.
Yeah.
We will have to start with the Supreme Court, which is the highest court of the land.
Okay.
Okay. Supreme Court is the highest court of the land. Just after the Supreme Court, we have the Appeals Court.
Okay.
Okay. We also have the High Court. Okay. These three courts form what we call the superior courts of judicature.
Okay.
The Supreme Court, the Appeals Court, and the High Court.
Okay.
They form what we know as the superior courts of judicature. Okay. Whereas we have inferior courts also in the form of the magistrate courts and local courts.
Okay.
Okay. So all of these courts that I've mentioned, they are very integral to our legal system.
Okay.
By way of when we talk of the hierarchy of our court system, from top to bottom, we have now the Supreme Court, we have the Appeals Court, we have the High Court, we have the Magistrate Courts, and we have the local courts.
Okay.
Okay. All of these courts have what in law we call certain jurisdictions.
Okay.
When they say this is the jurisdiction of the court, it means that these are the types of cases
they deal with,
that these courts look at.
Okay.
Okay. That they actually deal with, that they adjudicate or litigate on. Okay?
Okay.
So, for the benefit of our viewers, as we go along, once we make use of some of these legal terminologies, I will endeavor to break them down so that people understand.
So now, to start with, because we want to start having our viewers to understand the topic proper. Now, you've already said that the superior court, which happens to be the Supreme Court, and you have the Appeals Court, and then you have the High Court. And of course, we do have the lower courts ranging from the magistrates and that of the local courts. So now, trying to distinguish between the cases that they deal with, we really need to look at that. That is what I need us to look at next. What cases does the superior courts, ranging from the Supreme Court, Appeal Court, and that of the High Court deals with? What cases?
Yes, so generally, the judiciary of Sierra Leone has the jurisdiction to look at all civil and criminal matters relating to the 1991 Constitution. Okay, so when I say relating to the 1991 Constitution, every single law that has been propounded in this particular jurisdiction is an offshoot from the 1991 Constitution.
Okay.
Because the 1991 Constitution is the ground norm, which is the number one law. Okay. It's the highest law documents that we have as a country.
Okay.
Okay, so every single statute or legislation draws its power, draws its legitimacy from the 1991 Constitution.
Okay.
It's there is a section 170 of the section 170 subsection 1 of the Constitution, which shows all the sources of laws in Sierra Leone. Okay. And then you would have to see that the 1991 Constitution is the number one source of laws in Sierra Leone. So, as a ground norm of the land, all other laws are drawn from the Constitution, all other legislation. So, if you now hear about the Public Elections Act of 2022, it is drawn from the Constitution.
Okay.
Okay. So, if you now hear about the Courts Act, it is drawn from the Constitution. Every single law is drawn from the Constitution. Okay. So that is also the case with the jurisdiction of the judiciary, which has to do with all civil and criminal matters. As long as it relates to the 1991 Constitution, it is the jurisdiction of the courts to look at it, the judiciary. So we now come to the apex court in our judiciary, the apex court, which is the Supreme Court. The Supreme Court is our apex court, the highest court of the land. And
the final court?
Yes, it's the final court. Okay. Well, for the purposes of our jurisdiction locally, it's our final court.
Yeah.
Okay. But people can take their appeals to regional courts.
Okay.
Okay. as to the extent of their enforceability, we cannot now say, because we've seen a case where someone has taken his case to the regional ECOWAS court and he had a favorable decision, but he has struggled to enforce that particular decision of our courts in Sierra Leone. So for the purposes of this discussion, the Supreme Court is our apex court. Sierra Leone's apex is the Supreme Court. Okay, so, and the Supreme Court is provided for under section 121, subsection 1 of the 1991 Constitution. And it consists of the Chief Justice and 4 other justices. Okay. So when the Supreme Court is duly constituted, when it says duly constituted to hear matters, it has to be the Chief Justice and 4 other justices. Okay. So the Chief Justice, if he's not present, if he's unavoidably absent, he can now assign or delegate to the senior most judge, or the senior most justice of our justice system, of our courts, to preside on a particular matter on his behalf. So for the Supreme Court, 5 justices can sit and they will form a quorum. They will form a quorum. So when we say they form a quorum, it means that when a matter comes before the Supreme Court, you should see 5 justices sitting presiding over that matter. If you do not see 5 justices sitting presiding over that matter, it means that they do not, the court has not formed a quorum. So whatsoever decision they come to is not binding.
So to say, for the understanding of our viewers, you must have the 5 judges to agree on a particular decision.
There are more justices in the Supreme Court. Yes, up to 7. Up to 9.
So, but you need to have 5 of them.
Yes, 5 of them should be sitting.
To make a particular decision on a particular matter.
To form a quorum. When they say to form a quorum, it means that once a determination of matter is to be reached, these 5 justices should be present. So a classic example is this PR system petition that was brought before the court. We see it was on live television. We saw all the justices who were presiding over the matter. As a matter of fact, the Chief Justice was the presiding judge, and he had 4 other justices with him. So in terms of quorum, this is how it's supposed to be. You have the Chief Justice and 4 other justices sitting with him to preside over the matter. So the jurisdiction of the Supreme Court, when they say the jurisdiction of the Supreme Court, it simply means what types of matters the Supreme Court looks at. What type of matters it looks at. The Supreme Court has original jurisdiction. That's original jurisdiction. So in its original jurisdiction, it looks at enforcement and interpretation of any provision of the Constitution. So we will now run this session with certain examples, real-life examples.
Because, it's necessary.
We've now seen situations where a lot of petitions have been brought to the Supreme Court. Like, for instance, the one I just mentioned on a determination of whether the president had the right to make a proclamation that our elections will be run by a PI system. So the opposition party did not like that kind of proclamation made by the president. And so they litigated, they petitioned the matter to court, to the Supreme Court. So this is one of the original jurisdiction of the Supreme Court. So look into matters such as this, because the issue before the court stems from a certain provision of the 1991 Constitution. So the lower courts do not have the mandate. They do not have the mandate to look at interpretation of provisions of the Constitution. It is only the Supreme Court that has that particular mandate, that has that particular jurisdiction. Only the Supreme Court. So in its original jurisdiction, the Supreme Court will look at such matters. And then, of course, the Supreme Court handles matters relating to enactments of certain statutes that are inconsistent with provisions of the 1991 Constitution.
Okay, that is to say?
That is to say, for instance, you know, in my introductory statement, I have said all the laws of this country, the statutes promulgated, are drawn from certain provisions of the Constitution.
Yeah.
Okay? So if a statute is now being promulgated in Sierra Leone, it's been drawn up, it's been drafted, and it is inconsistent with provisions of the 1991 Constitution, someone can now petition this particular statute, and the Supreme Court will now look into the matter because it's the only court with the jurisdiction to do so. Okay, we look into the matter, and if as a matter of fact, they find that the provisions of this legislation are inconsistent with that of the Constitution, they will do an interlocutory injunction and stop whatsoever legislation from carrying forward.
Okay.
Okay. So these are the when we say the jurisdiction of the Supreme Court, these are the matters that the Supreme Court looks at. And of course, the Supreme Court has appellate jurisdiction.
Okay.
Okay. When we say appellate jurisdiction, it simply means that matters that have been determined in the lower courts, but one of the parties are not fully satisfied.
Okay. With the outcome.
Yes, they can now appeal to the Supreme Court.
Okay.
Okay, so let's say a matter is being presided over at the High Court. Yes. Okay, and the High Court has now come to a determination of the matter, and one of the parties say, okay, on point of law, I do not agree that the judge presiding over this matter actually came to the right decision. So,
but as you stated, it always has to be on the point of law.
Yes, of course. Your appeal should be on the point of law. You cannot just appeal out of a vacuum.
Okay.
Okay, so it has to be on the point of law. Okay, so there is what is known as the leapfrog approach. Okay, so you cannot appeal and your appeal go from the High Court and it goes directly to the Supreme Court. It has to first of all go to the appeals court.
Okay.
But there are certain appeals which leapfrogs the appeals court and go directly to the Supreme Court.
Okay.
And this is not unconnected to issues relating to enforcement and interpretation of provisions of the Constitution.
Okay.
And the enactment of certain legislation that are inconsistent with the provisions of the 1991 Constitution. Okay? So in its appellate jurisdiction, the Supreme Court also looked at some of these issues. The Supreme Court, being the highest court of the land, supervises the other
courts.
Yes, other courts, all the other courts in the land. So it supervises all of these other courts. So we now move on to the appeals court.
Okay.
Okay. Even by the nomenclature, appeals court, we know that the appeals court has appellate jurisdiction.
Okay.
Okay. But the appeals court is provided for by section 128, subsection 1 of the 1991 Constitution, and it consists of the Chief Justice and 7 other justices of the Superior Courts of Judicature. Okay. Okay. So, for, like I have said, for a determination of a particular matter before the appeals court, for it to be duly constituted, 3 justices have to be seated.
Okay.
Yes.
Okay.
3 justices have to be seated to come to a determination of a matter before it.
Okay. So the number that seats for Supreme Court matter is different from that of.
Yes, it's 5. Okay. For a Supreme Court matter to be considered duly constituted,
is 5.
There has to be 5 justices.
Okay. And for
the appeals court, there has to be
3 justices. Okay. Understood.
It has to be 3 justices that has to be seated. So if you now have an appeal before the appeals court, you see only a justice sitting before presiding, then you know the quorum of the court is not duly constituted. And whatsoever decision that particular justice comes to is will be null and void. You can just appeal that particular decision easily to the Supreme Court.
Okay.
On the grounds that the court was not duly constituted.
And that is something that you cannot go away from because it is the law, right?
Yes, of course. It is clearly laid down in the law.
And what happens in the High Court?
Yes. Now, for the purposes of the High Court, we see here section 131, subsection 1, making provision for the High Court of Sierra Leone and the fact that how it should be duly constituted. Okay. So for all of these courts, we have the Chief Justice.
Okay.
The Chief Justice, because he's the titular head of the judiciary, he has to be present in all of these courts, but he can actually delegate.
Okay.
Yes, he can actually delegate to judges and senior justices when he's not around or when he's not chanced. So even for the purposes of the High Court, it should be the Chief Justice and not less than 9 High Court judges. Okay? Not less than 9 High Court judges. But in the High Court, only one judge can constitute the court.
Okay.
Yes. We have certain matters where the judge will sit and preside over the matter all by himself, or on the election of the accused person, we can see a judge and a jury. Okay? So for instance, now in the instant case of the case versus Sierra Law and others, anti-corruption case, if the accused persons are elected, for there to be a jury, for it to be a jury trial, then the judge would have been there presiding over the matter alongside with the jury.
Okay.
But the accused person is elected against the jury.
Okay.
So the matter is presided over only by the judge. Okay. The jurisdiction of this court is wide range. This is a wide range jurisdiction court because it covers a range of civil and criminal matters. Lots of civil and criminal matters. But it also has supervisory jurisdiction over the inferior courts. So it is the role of the High Court to supervise the inferior courts.
Okay.
Okay, and these inferior courts we've highlighted it earlier before.
Okay.
To be the magistrate courts and the local courts.
Yeah.
Okay. Yeah. All of these courts have to be filled with justices and judges.
Okay.
So therefore, these people have to be appointed to these positions. Okay. To serve in these capacities. But they cannot just appoint anyone. They cannot just appoint anyone.
Then almost
they have to meet a certain criteria.
Okay. So
be appointed.
So sorry to obstruct you along that line. It is very key for people to get this very clear.
Yes. And
we want to use a case study as a reference. That is a very, very loud one, especially when you mentioned the Saidu Nalo versus and others versus the state. The presiding judge, lots of people have this belief that he wasn't, he didn't meet to the criteria before he started presiding over this matter. That is to say, Parliament did not approve his position as a justice of the High Court of Sierra Leone. And to say, when these appointments are being made, how does it normally go before that person come to sit or presides over a matter?
Yes, a wide range of criteria are looked at.
Okay.
Yes. So every single hierarchy of the court has certain criteria that the individual must fulfill for him to be appointed to his roles. For the purposes of the Supreme Court, the individual must have been a practitioner in Sierra Leone for over 20 years.
Okay, for over 20 years.
Be a practitioner for 20 years and over, standing.
Okay.
Yes. So with 20 years standing, and you are still allowed to practice law in Sierra Leone, because for you to be allowed to practice law in Sierra Leone, you have to regularly update your status.
Okay.
With the General Legal Council and the Bar Association of Sierra Leone.
Okay.
Yes. So, and also you have to be a practitioner who can practice law in another jurisdiction with a similar legal system to Sierra Leone, a legal system analogous to Sierra Leone.
Okay.
So, for instance, like the British legal system, Sierra Leone's legal system is almost the same with the British legal system. So most of what you see in the British legal system, we copied.
Okay.
Okay. And it forms part of what we do here in Sierra Leone. Okay. So it is called the common law legal system. So any other jurisdiction that does the common law jurisdiction and is analogous to what we practice here, yes, and you have practiced law in Sierra Leone for over 20 years, and upon your appointment, the parliamentarians who are, it's their responsibility to scrutinize you, our House of Representatives. If they find you worthy, then of course you can now be a justice of the Supreme Court. After the approval? Yes, after the approval. Okay, so for the purposes of the appeals court, it has to be 15 years standing. Okay. You should have been at the bar for 15 years, and you are capable of practicing in other jurisdiction analogous to that of ours, and your status as a practicing barrister is still up to date. Because this is a very interesting criterion that your status has to be up to date, because we have lawyers who fall foul of the law. Okay, yeah, yes, yeah, their names are struck off. It's true. And their names are struck off from the rule. So if you find yourself in that particular capacity, then, or in that particular predicament, then you will not be qualified to be sitting on the bench. Okay? So for the purposes of the appeals court, you should have practiced for 15 years and all the other attending criteria. Okay, and for the purposes of the High Court, you should have practiced for 10 years. Okay. Yes, you should have practiced for 10 years and all the other ones that I have mentioned. Okay, you should have good standing with the General Legal Council and the Sierra Leone Bar Association, and you should be able to practice in that jurisdiction analogous to Sierra Leone. Okay. Of course, we have the preliminary criterion, which means you should have a first degree in law. Oh. Yes, you should have a first degree in law. So as an High Court judge. Yes, all the categories. Categories. Okay, okay, so okay, okay. In law, and you should have gone to a bar school, so which we call law school. Law school, yeah. You should have gone to a law school, and if even you did not do same in Sierra Leone, you should have done same in a country analogous, practicing almost the same type of laws that we do in our legal system. For the magistrate courts, you don't need to have practiced for any number of years. You can make an application to the council and the Judicial and Legal Commission, and they will look at your application and then appoint you to the magistrate court. So you don't need any number of years of experience. Okay. You just need to have studied law in Sierra Leone, passed the bar, and you could sit. And the magistrate courts, and the magistrate courts heads, or let's say the magistrate is being appointed by the. Who appoints the magistrate court? A magistrate. All appointments are done by the executive arm of government. Okay, but on the recommendation. On the recommendation of the Chief Justice. Okay. Yes. On the recommendation of the Chief Justice, all appointments are done. So this is where I have a problem. Okay. As a practicing barrister, I believe that appointments for the sake of judicial independence, proper judicial independence, appointments should not be done by the executive arm of government. Why do you think so? Because there is this old adage that he who pays the piper dictates the tune. Okay. Yes, and do you think that has been the case of our judicial system? Has been the case. This is why our judiciary is usually accused of not being independent. Okay. Yes. If I have nothing to do with the executive arm, if the executive arm do not have the power to hire and fire justices of the Supreme Court, the Appeals Court, and the High Court, then these people will have the free hand to come to justiciable determination of matters free from executive interference. So you think the executive being the one to appoint these judges automatically is a disadvantage on the independence of the judiciary? Yes, seemingly so. Okay. Because we will now find ourselves in a situation where, there's a conflict of interest somewhere. Okay. Where I appoint the people that I know will play ball. You understand? I will appoint people who will play ball to my particular agenda and narrative.
Okay.
Yes. But whereas we have a particular independent commission who appoints judges, who appoints justices, who appoints magistrates.
Do you think that is possible? And if it is, how can we go about it?
It is possible. It is very, very possible for us to achieve something like this.
How do you make a recommendation for us to have a very independent body? Because again, you want to look at it from a point that who is going to be overseeing this independent body as well?
So is he the first African American president of the United States, Barack Obama, once said that strong institutions are the backbone of a nation.
Okay.
Okay, so once we have strong institutions, we now see total independence of these particular institutions. And this will translate into people having the civic sense that we are working in the public space for the general good of the masses.
Okay.
And you do not have to have loyalty to your paymaster or the person who actually appoints you. Okay? So once we have a particular commission for the appointment of justices, judges, magistrates, independent of any political stranglehold, then we will see a situation where these justices, these judges, and these magistrates will come to a determination of matters before them that hinges on, that have very strong political undercurrent.
Okay.
They will come to decisions which the masses will accept. Because we have the saying here in Sierra Leone,
it is a common saying.
Yes. And even of course, I will not get into trouble for mentioning Justice Fisher, who is presiding over the state versus. He made mention one of these days when the learned Africanos raised the objection that
on the video vising,
the stage at which the trial is now, the court should not allow video vising of the proceedings.
Okay.
Yes, that was his objection. And in the arguments, the justice said, well, people are considering me to be an
SLPP judge. Yes.
Because I was appointed by this.
Yes, it was very loud saying that.
Yes, so because he was appointed by this president, people have that perception.
Yeah.
You understand?
Yeah.
We have judges in the court who are still there, who are appointed by an ESCOMAN, and they are considered to be APC judges. And this should not be the case. If we have an independent body that does these appointments, you see the person as an independent person. He has come to the court on his own merits.
Okay. So this appointment, where does the power lies that the executive just has to be the one to make this appointment?
So I think this is a constitutional problem. We have to amend certain provisions of our constitution.
Okay.
So that we do not continue to run into this problem. The executive arm was given so much power in the constitution such that the president can hire and fire anybody. And the president should not be able to fire a Supreme Court justices. He should not be able to fire judges of the High Court or the Appeals Court. Because these people have tenured offices. When I say tenured offices, once you are appointed, there should be a particular number of years that you should serve.
And what is it, the tenure for, let's say...
They should be there till age 65 years.
Okay, once you are appointed as a judge.
Yes.
Oh.
If you are appointed as a judge of the High Court, barring any wrongful conduct, you can be promoted to Appeals Court and Supreme Court, as the case may be, as you keep serving diligently until you are 60 to 65 years of age. It is upon your own volition that you now resign or retire. I am tired, I don't want to work anymore. These are tenured offices. But we now see situations where there's a lacuna in the law where the president will just get up one morning, he did not wake up very properly, and say, okay, this particular justice should now go on indefinite leave. It should, the constitution should now make it in such a way that it should not have that kind of power.
I think I would want to agree with you on that.
He has direct control into a separate arm of government. When the three arms of government were being postulated and promulgated by this particular philosopher, he had in mind, they understood what they were doing. It was clear thought that these three arms of government should exercise their powers independently to serve as checks and balances on each other. So we cannot see a situation where the executive exerts control on the other two arms of government.
Okay.
Once that happens, the executive can do whatever it likes. And then we will be worse for it with the general masses. And because certain decisions and actions will be taken with impunity because it is coming from the executive. We hear from orders from above.
Okay. And the executive in all of this would never be seen as an independent body, right?
The executive is the most independent.
Okay.
Because nobody exerts control on the executive.
Okay.
Yes. Nobody exerts control on the executive. It is the executive that tries to exert control on the other two arms of government.
Okay.
And this should not be the case. Now, this is why the United States is the model of this particular system.
Okay.
Sierra Leone is a picture, is a mirror image of the democratic systems that is being applied.
Okay.
Mirror image. Because they have the presidency, which is the executive. They have the Congress, which is their House of Representatives. And they have the Senate.
The Senate.
Which is their judicial. They have these three arms of government, you understand? Every single arm of government works independently from the other. If the executive does a mishap, the Congress calls the president to come and answer to questions. Yes, the Congress does that. When have you seen in this country that our parliament, our House of Representatives, has ever called the president to come and answer? We had an opportunity for them to call him when Lara Telopias published the 2019 audit report. And there are some damning details in that particular report about the operations of the executive arm of government with regards to foreign travels. The House of Representatives should have now called the president to question him on same.
Yeah, this is a very spotlight statement that you're making now.
They do not have the gumption to do so because everybody is afraid of the executive. I simply do not understand why. Because the same powers that the executive arm of government have, it's the same powers that the legislature has, and it's the same powers that the judiciary has. The same.
Okay, but in this case of Sierra Leone, and I think to agree with you, it's giving more power to the executive arm to be making appointments renders these other bodies that are supposed to be independent very, very disadvantageous. Yes. In the sense, like you've stated, I mean, in common language, I mean, you know they bet the hand where they feed you.
Of these three arms of government,
yes,
relates to Sierra Leone, I am mostly disappointed in the legislature.
No, agreed.
Yeah, because the legislature, the executive cannot exert control over the legislature. Because members of the legislature are equally voted for in a democratic process as compared to members of the executive. Okay. As a matter of fact, the members of the executive, it is only the president that is voted for and is running meet. And they now make appointments of all the other executive members, which are the ministers, members of cabinet. So, but when it comes to the legislature, every single member of the legislature are voted for by the people. They are the people's representative. The president can neither hire nor fire them.
But most times
we have seen in this country a very erroneous judicial decision where the courts came to a decision that members of parliament that have been elected by the people should lose their status to some other people. This should never have been the jurisdiction of the court.
Okay.
So to duly constitute the House of Representatives, it has to be the will of the people.
But
once the people vote and they now have their elected representatives, the court does not have the power. The courts do not have the power to determine who should fill the House of Representatives. What the court should have done, I am challenging the courts now, what the court should have done is to now ask for a rerun of that particular election. So if you now find that there are some discrepancies in the results and some irregularities as it pertains to the petitions brought before you, you should ask for a rerun of the election. Because it is the mandate of the people to fill the House of Representatives, not the mandate of the court.
Okay.
It is not the mandate of the court. It's the mandate of the people, we the masses. We should now go back and vote for our representatives to fill, because these are the people who represent us in our constituencies. Okay? So now the court will now go and put a less favorable person that we did not vote for.
Is that not what we're going to see with the PR system as well?
Yes, this is why I mentioned the last time that this is not my favorite system of an electioneering process.
Okay.
Especially for members of the House of Representatives, because they are not coming from the people. It's not the people's choice. And democracy, the principal function of democracy is the representatives of the people.
Okay. One spotlight statement that you made is the fact that we've never seen, in the case of Sierra Leone, the legislative arm of government calling on the presidency or the executive to come and answer to certain questions. Most times we see them calling the ministers, heads of government parastatals and agencies, but we've never seen the presidency facing parliament on, I mean, let's say there are issues that has to do with national development. We've seen in the case of other countries, I will use South Africa for example, they called on the president to talk about... These
are progressive nations.
Okay.
They understand the tenets of democracy.
So now
let's know that the president is the people's representative. The president is the #1 servant of the people. And as long as a people have that kind of understanding that their president is their servant, their representatives in the House of Parliament have the right to call the president, you as the servant of the people, come and account to us as to why you decided to take this particular action, which seemingly so is adverse to the interests of the general people, the general public.
Okay.
Yes, because I think it's the level of understanding in Sierra Leone that is too low. We need civic education. We need people to understand that members of government are not doing us a favor. They are our representatives, they are our servants, they are there to serve us. We are the bosses. They are not our bosses. We have made their lives very comfortable and convenient so that they are in a fine position to serve us.
Agreed.
They cannot use the luxury that we've given to them to intimidate us. You understand? So most people in this country feel intimidated such that even our House of Representatives do not have the gumption to call the president to ask him certain questions. Because they are now afraid, he's very powerful. What if he catches wind of the fact that I was the one who initiated this motion?
Is this as a result? Is this as a result? Because on the part of the legislature, I want to think, I am being voted for, just as you've been voted for as the president of the state.
Yes.
But coming to think of it, we've seen our presidents being the leaders of their political parties. Couldn't that be the reasons why most of these parliamentarians just succumb to the dictates of the executive? Couldn't that be?
This is why I say there is a need for civic education, so that even the representatives that we send to parliament, whether they go there through their political parties or as independent candidates, they should know that my #1 or primary objective as to why I'm in the House of Representatives is to represent my people, not to represent my political party. It's to represent my people, not to represent...
But as in the case of this PR, I think it is going to be represent your party. It's no more going to be the people.
It's the party that comes up with the list.
Yeah.
Once you don't seek the interest of the party in parliament, when it's the next time for election, they will not put your name on the list.
Agreed.
Put your name on the list.
If you're just joining us, the program you're watching is Legal Matters, coming to you on TDN Africa Media Live. And with me in the studio is Emmanuel King. We're going for a short break, and when we come back, we'll be putting down the curtain for today's program. Hello and welcome again to the program Legal Matters, coming to you on TDN Africa Media. And today we're talking about the Sierra Leone legal system and the role of the judiciary during our electionary process. And today we've highlighted the different courts and the role, the judges, ranging from the Supreme Court judges, the Appeal Court judges, the number of judges that the High Court needs to preside over a matter. We've talked about lots of other issues that has got to do with the legal system of Sierra Leone. And now, to help our viewers understand what is really the role of the judiciary when it comes to our electionary process, especially so when now we're into elections.
Yes, we've seen the judiciary in motion already with regards to the electioneering process. Like I said in our last program, that elections are a process. Okay. And we've seen the Electoral Commission for Sierra Leone started the process a long time ago. And because of the processes, we've seen litigations in courts and for a determination of certain issues. Okay, we've even seen by-elections which have come before the courts for a determination. So the role of the judiciary is to uphold the law, is to look at the petitions brought before it by aggrieved parties.
Okay.
Yes, to look at petitions that are brought before it by aggrieved parties and then determine, given the facts of each case. So the role of the judiciary is not far away from the usual role that is played to hold the balance in society. So electioneering processes are one of the processes that we have in society. Okay? And so when there is an anomaly, when there are irregularities, when a party feels that I have been disadvantaged because of X, Y, Z reasons, it now makes a petition to the court.
Okay.
Makes a petition to the court, and the court will look at this particular petition. This is the case because we realize that most people, especially in the African context, when they feel aggrieved in the electioneering process, they take to violence. But the only way that you can have recourse in electioneering process when they are irregular, when they are perceived irregularities and the likes, is to make a petition to the court. But herein lies the problem. The people's distrust of the court.
Okay.
Yes, the people's distrust of the court leads to violence again. Because if I believe that when I make a petition to the court will neither listen to my petition, nor looks at the merits of the case of my petition, and at the end of the day, will just throw it out, even without me considering the facts that are brought before it, then the people will look for an alternative to settle their scores. And usually in the African context, the alternative is not a nice one.
Okay.
So I should join my voice with very many civil society organizations, international non-governmental organizations, to ask the people to exercise restraint and write their petitions, petition the court, petition the process, so that the court will look at it and come to a determination. And I also want to encourage the court So look at the petition of the petitioners that come before the court with these elections irregularity matters in a speedy time, expediently, such that every party does not feel aggrieved at the end of the day and decide to resort to violence. Part of the reasons profiled by the TRC for our 1991 rebel war that spanned for a number of years are some failures of our judicial system. Okay. And among these failures, it was captured that when election petitions are brought before the court, they are not properly considered. We see the courts tend to tilt to the victorious party more than an aggrieved party. Okay. As I have mentioned, I am also of the opinion that the court should not have taken the victory away from the members of parliament that won their vote through the electioneering process and give it to the next in line. What the court should have done was to order for a rerun of all these elections, regardless of the cost implication. Because you have to give the mandate to the people to elect their officials. It is not the business of the court. It is not the business of the court, especially on the House of Legislature. Especially on the fact that we were supposed to be having a constituency-based election. Yes, it was a constituency-based election, and the over close to 10 members of the opposition party lost their seats because the court gave an order that the person that came second, who was closest to the winner, should not take it. This is not the case, because the fundamental principle of democracy is such that the people elect their representatives by a majority. So the court, what they did was saw a minority now taking the representative capacity of the people. We saw a minority taking the representative capacity of the people. And this goes against the tenets of democracy. Because democracy, for the most part, is majority rule. Even though minorities do have rights, but they do not have representative rights. It's true. When you are a minority, you are a minority. It's true. If you want to turn your minority into majority, control the people with very good policies. The court should have now given an order for a rerun of these elections, and this person with the minority will now turn his minority to majority by convincing the people with very good policies that these and these and these are what I will do for you when I am representing you in the House of Representatives. Okay, so as we're about to bring down the curtain, but before we go, already we've started seeing the distribution of voters' ID card, and people have started receiving theirs, and there have been lots of complaints around that. But from the law side, and being a lawyer and a Sierra Leonean, now talk to the people. What is the best way to go about, whatever challenge that they're facing so far, and to those that may have not collected theirs, to please do? Okay, so it's quite, well, in principle, it's quite simple. Once you go to collect your voter register and you find out that the details on the voter register are not your exact details, you can take the issue up with the officials that gave you the voter ID card and distributed the voter ID card, and they will direct you to the Electoral Commission of Sierra Leone for you to further petition them as to why your details are not correct. If you do not have exact answers, you can then petition the matter to court. You can come before the court and say, well, I am a registered voter, I registered with XYZ details, but I have not been able to get my card because of XYZ reasons profiled by the commission. And I want my card because I need to vote in this election and exercise my right of franchise. Okay, so the very first port of call is to go to the commission and make this complaint. Maybe it was a human error. They just made a simple mistake. Okay, which they can rectify. But if they cannot rectify it and they want to disadvantage you from voting, then you can now come before the court speedily, and the court will now look into the matter. So that is what Mr. King have got to say. If you've found out that you went to the registration center where you did, and now you're about to receive your ID card, after you may have received it, if you notice that the information which you gave them was not
what you've seen on the ID card after you've received it, make sure you tell the people that you first met at the poll, and then you take it to the appropriate authorities. Or you can push your case forward to the courts of Sierra Leone. The program have been Legal Matters, coming to you on TDN Africa Media. I've been your host, Amadu Esba. Here we'll put down the curtain for today's show. Don't forget, this program comes up every Tuesdays and Thursdays, starting 11:30 up to 12:30. Today we're giving you a bonus of time because we started a bit late. Thank you for being part of the program. I've been your host. Bye-bye for now.